Howdy folks, it's Dr. Jeff Camardo, your Wealth Doctor. Welcome to yet another edition of Smarter Money Matters with our Super CFPs, Anna Wunderlich and Lou Vercel. This week we're talking about, again from the Wall Street Journal's Inspiration, this article called Leaving the Wrong Beneficiary on Your IRA Plan Can Be a Costly Mistake. So what are we talking about? There's a whole webinar that we've done. The area of using beneficiary designations on IRAs or 401ks and even life insurance and other things that pass by beneficiary, even pay on death and transfer on death accounts, right? It's a very, very, limited functionality in terms of what you get. You can't use, and we're going to talk a little bit about why trusts make more sense and some of the pitfalls, but it's very, very, rigid, and you have to be careful to follow the rules and keep up with the rules, right? So you want to check, the people that on a frequent basis that you've named who you want the IRA money or 401k money to go to. Also check your parents' accounts would be a good idea, and keep up with it because things change. Your wishes change, the players in your life change, divorces come and go, people become estranged, people die, and if you don't go back and keep up with this stuff and then you die, you're pretty much screwed. The options to repair it are between nil and none. So people, according to quote the article, people pay attention to their wills when they sign them, but they fill out IRA and 401k beneficiary forms without really thinking, and then they forget about them. And you guys get a lot of this work from new clients that are coming to Camardo Wealth to a portfolio management and financial planning services. Do you find that's, do you have a lot of messing up to do?
I don't know if there's a lot of messing up, but there's certainly an important area to keep, to talk about. And the reason is these, registered qualified accounts like IRAs, 401ks, they bypass the will. They bypass probate. So if there's a beneficiary on that account, no matter, you may have a different beneficiary in your will. If it's not updated on the account, that's the one on the account is going to be the one that's going to be executed first.
So if we're brothers and you went to work at a company in your 20s, maybe it's a tech company, and now there's $7 million in your 401k because you put it all in company stock. Happens a lot, right?
Sure.
And then subsequently you get married, and actually that probably wouldn't be a good example with marriages. But say that something happens to me, and your secondary beneficiary is going to be our mother.
Maybe I have a child or something like that outside of a marriage, right? Yeah. That could be a good example.
But what can happen though is that if you don't keep up with that stuff, your child will never get the money.
Correct.
I'm dead, our mom's died, and it winds up going, to the provincial government in Ontario or something.
Correct.
Whatever the laws of intestacy are up there, in the Great Northwoods.
Correct.
You have a comment?
Yeah, no.
Music.
You're fine. No, I think kind of to piggyback on what you guys are saying, like when people are setting up these accounts, they're probably enrolling in a new job. So they're doing their health care, their payroll, all that stuff. And this is just, that 401k is just one piece that they have to get done when they're onboarding. And they might even blow past it without putting somebody down or just throw someone's name and never check.
Yeah, just to get through, to just get on with their job without giving it the thought that it really deserves. And we're talking about a lot of money in some of these accounts, folks. You know how much is in your IRAs and your 401ks, or maybe, so it's also really, really important. You can unsnarl this stuff while you're still living and thinking about it, but once you're dead, and we've had, a number of horror stories with our clients who didn't keep up with their documents, it becomes virtually impossible. There are probate considerations, there are tax considerations. It really, really can become
and in a lot of
quite
cases,
a mess.
And in a lot of cases, you can't go back and make the change after that. But it's a done deal.
And here's an example about this one young lady that made his sister the heir of a very small retirement account. I'd like to give her something, and as the years passed, that account just grew into the biggest single asset that she had. And when she died years later without changing the form, it was the largest asset in her estate, and her sister got the money instead of her husband and children, which would have been her wish. So there's a lot of ways to go wrong here. It's worth spending the time. One thing you don't want to do is name your estate as the heir, right?
Correct.
You know, for particularly because other than the delays and the confusion and introducing probate, if you do that, it's got to be a probate asset if you name your estate. You're also really screwing yourself out of some pretty significant tax advantages that you would otherwise have as options. And again, watch that long webinar that Megan is going to post the link. We're not going to get into the nuance of taxation here, but you really got to be careful. Since the Secure Act 2, you know, and the fact you can no longer stretch RMDs, required minimum distributions, out over real long periods of time. If you don't do it right, for a spouse it's going to be a lifetime, for others it's 10 years, but if you don't check the right boxes, it's all taxed in 1 year, which can be disastrous, right? What happens then?
That's a large tax bill.
It's a large tax bill. 1 year you don't get the deferred, and it's probably going to launch you into the highest tax bracket, where you might have been able to milk it out at 10 or 15 or 20% tax rate over a longer period. If you get $2 million in 1 year, it's all going to be the highest rate. You might lose half the money.
And it becomes a snowball effect. You know, it can affect your Medicare premiums. You know, it's a lot of headaches that can happen if in that instance.
Shall we get the talking stick to Anna?
Sure.
What do you got to say, Anna?
Oh, I mean, I was going to add that the trust and estate tax brackets escalate very quickly as well, right? To just piggyback on the point Jeff was making, if you designate your estate and it all comes out, you're talking about the 35% or 37% bracket very, very quickly.
Yeah, in terms of your income bracket,
Yeah.
plus any state, income tax considerations that may arise, and you also want to make sure you got backup beneficiaries, right? The so-called secondary and tertiary beneficiaries, where my spouse is my primary beneficiary, and all children to share equally per-stirpes would be secondary. That's a pretty common and useful pattern. That you can do a lot more with a trust. And what does that mean? That's if I die, my spouse, my wife gets everything. If she dies first, then all my children get it, and they split it. And a per-stirpes just means it's Greek for down the line.
Branch.
So if I have branches. So if I have a child that dies before I do, then her share or his share would go to his or her kids if there are any. It goes down the branch. If there is no further branch, then it gets split among the other ones, right?
Per capita. Yeah.
Per capita, yeah. So
Well, that's a very important consideration, though. And those are the two options that you have on your IRAs and 401ks as an election. How to, and obviously that's important to know and understand that, because if something happens, somebody predeceases, like using your example, having 3 kids, one of them passes, and then if you want to leave, they have a family, you want to leave their portion to their kids. If you elect per capita, that would not be the case. It would be split up between the two remaining.
Which is another reason, we'll get into trust in a little bit, but I think there's so much more flexibility by using trust that I can't imagine anybody not doing that with substantial means, as most of you probably do. So another thing is you want to complete, new forms every time you transfer an account. It's an excellent catch-up opportunity to get things right. As you change jobs, and maybe you move that to an IRA. A lot of our new clients are transferring 401ks or IRAs from wherever they are to our custodian, which is Schwab, and then we go through the paperwork again and confirm and discuss give them input as to how to properly select a beneficiary pattern.
Yeah.
That's a good time to fix it.
And part of our planning process that we do here is an annual review of their beneficiaries, making sure they have them on file. Reminding them of who they are, and often clients want to change them, after we have the discussion.
If they're prompted,
if needed to, yeah.
Which is why, I think it's really important that we've kind of baked that into our ongoing financial planning process to bring this up and have these conversations. Because a lot of folks are out of sight or out of mind, and they really appreciate the input and the alternatives to perfect the beneficiary situation. But I don't think a lot of advisors bother. They kind of fill out the form, they got paid, and they were done.
Yeah, no, absolutely.
And you have some really, really old inappropriate beneficiaries that people come to us.
To answer earlier point, especially on IRA accounts, it may have been set up 20, 15, 30 years ago, whatever, and then it hasn't been looked after, and it's an important thing to check on once in a while and make sure you still have the beneficiaries.
Nothing makes the current spouse matter than seeing the IRA going to the first wife, right?
Yeah.
Or vice versa.
Exactly.
Ladies. So it's important to understand the 401k waiver for spouses. I think by law, you must make your spouse the beneficiary of retirement accounts unless you get a waiver. So if you want a different pattern, you've got to have the spouse sign off and say, it's okay, I'm waiving my right to be the primary beneficiary of this account. And that's really, really important in order to make sure things flow the way that you want. Right? Again, citing from the article, she says, say an employee remarries after her first husband dies, she wants her children to inherit a 401k and names them on the beneficiary form, but if she neglects to get a waiver from her current spouse, then if she dies with a 401k, her spouse will inherit the account, not her kids. Disastrous and probably completely off her radar unless you watch this podcast or got it from another source. Really, really important to remember that.
And if that spouse had a kid, kids from previous marriage or previous relationship, potentially that money could be ended up in their hands as opposed to the wife's kids.
Exactly, yeah. Or that kind of stuff happens all the time. Now, in this fact pattern, she dies, it goes to her husband instead of her kids, right? And then maybe they're in a so-called common disaster in a car wreck, but he lingers in the hospital for 2 weeks. So the money passes to him, he dies, and then it goes to his kids. It's instead of her children. So it's really, really important, which is why I want to spend the balance of this talking about trust a little bit. But you will also, this is also one, know how defaults can help or hurt. And a lot of institutions, which you'll learn more about if you watch the webinar, IRA, the 401k beneficiary blunders really gets into the weeds on this and gives you a lot of very specific information. But there are a lot of institutions that have their own default patterns that may or may not be what you want. If you do this and you don't name a secondary beneficiary, then they choose one for you, so they can just get the to-do off their books. It's not going to be the best thing for you, but they got to close it out somehow. So if you don't tell them what to do, they're going to do something, and it may not be what you want. Which again is a really good reason, if you have reason to have a living trust, and most of you should, have the right provisions in the trust, which our attorney calls flexible spending provisions, to maximize the tax benefits. But then you can use the trust and be more specific. I want the funds to be available to my current spouse to supplement her retirement income as needed to the standard of living, but then the balance will go to my 5 children or whatever it is you want. You can have a lot of finesse. And if this person dies, then this happens. Or if that person, turns out to be a drug addict, then this happens. You can have a lot of specificity to really protect and control the money, which is just impossible with beneficiary designations.
I have one example to share, so that's a very good point. But clients also have to remember to, once they update that trust, goes to our earlier point of having a will but not having it on the actual account. If you do decide to get a trust and to go through the process of doing that, make sure you update your accounts. Make sure you name the trust as a beneficiary on your accounts, so that when the time comes, the trust is going to dictate how the funds are distributed as opposed to whatever the beneficiary may be on there by default.
Yeah. And review at least annually, as Anna was talking earlier. Go through the whole schmear of everything that your estate asset distribution channels, whether you have beneficiaries and have a trust, and you've got some real estate that will pass by operational law, basically somebody else's name is on there, whatever it is. Look at the whole asset structure and how things will pass to make sure they wind up going where you want. Last word, Anna?
Yeah, working in the industry, we've been on the side of the beneficiary that goes to inherit accounts like this, thinks that they're the beneficiary, maybe they're not, it has to go to probate, whatever it may be. It's a simple exercise every year. Take a couple minutes, look at your accounts. Now that things are online, it's very easy to see, and just make sure it matches what you want.
Well said. Thank you once again, folks, for suffering through yet another edition of Smarter Money Matters. Until next week, thank you. Have a profitable week. Bye-bye.